we're going to learn pasal burden of proof. Okay, next. So this is kita punya outline. Kita akan cover first kali the definition of what is burden of proof. B stands for burden of proof. Then kita akan cover the importance of burden of proof. On whom does the burden of proof lies? So exceptions to the general rule, legal maxims and related provision. Okay, before I proceed, kan I bagi tahu kan you all boleh beli a compilation of the laws dekat Pakistan dengan Brunei dengan Malaysia sekali. You boleh beli dengan Ustaz Hamid Jusoh lah. Yeah, I think it's $50 per book lah. Yeah, so the compilation of everything. Okay, next. Okay, so what is burden of proof? Okay, it comes from actually burden of proof ni dari a Latin word, maknanya honest probandi. Basically, it means on whose duty it is to prove the case. Okay, let's say you plaintiff, you know, you nak buktikan, you nak dakwa. Contoh, I kasih simple example lah. Contohlah macam Fatah Amin kan dengan Fazura tu. So dia nak saman Fazura, dia nak saman malu Fazura. Pasal apa? Fazura kata dia ni curang, tapi sebenarnya dia tidak curang. Lepas tu dia bagi tahu semua orang yang Fatah Amin ni curang. Okay, so it's on Fatah Amin to prove that Fazura ni actually created the rumor, buat fitnah tu. So dia kena buktikan. So bermakna the burden of proof is on Fatah Amin to prove that Fazura actually sebarkan the fact that yang dia ni curang, padahal dia tak curang. Contoh okay. So kalau ikut the legal definition, it will be the obligation placed on the party to produce evidence to satisfy the court as to the existence or non-existence of a fact contended by him. So he must prove, in the case of Fatah Amin, he must prove that Fazura did make a fitnah and the fitnah was indeed disebarkan. Benda tu exist. And dia kena dia kena prove juga bahawa sebenarnya fitnah tu tidak betul. Macam tu. Okay, next. Okay, so why is it important? Okay, number one, to determine which parties should prove his or her case. Number two, it depends on the case actually. But generally, it lies on the person who makes the claim, which is the claimant. Bermakna kalau let's say you're the plaintiff, kan I dah ajar kat you hadis yang al-baina ala mudai wal yamin ala man ankara. Jadi the person who alleges, he has to come up with proof. This is a court of law. You go to court, you don't have any proof, you cannot win your case. There's no case to proceed. Pasal apa? You tak ada nak buktikan you punya tuntutannya. Okay. So on the other hand, the defendant has to defend. He has to rebut the case against him either by bringing another evidence or to take oath to. Sambung bawah sikit. Alia. To deny the claim. Okay. So bila mana plaintiff tu kena kemukakan bukti, kena come up with evidence to prove dia punya case, kan? Therefore the defendant dia tak setuju, so he has to take oath lah untuk deny benda tu. Okay, contoh another example I kasih kalau case nafkah. Okay, so kalau macam case nafkah anak. Okay. I use a simple, I actually say my example juga. Case Fazura dengan Fatah Amin. Fazura claims that dia punya husband tak pernah kasih nafkah dekat dia. Okay. So katalah dia buat tuntutan dekat mahkamah. Dia kena buktikan bahawa she never receive any nafkah from Fatah Amin untuk nafkah anak dia. Tak pernah Fatah Amin kasih. So bila let's say dia dah tunjukkan dekat mahkamah, memang dia tak pernah kasih nafkah pun. So the burden of proof is shifted to the Fatah Amin to show that I sebenarnya dia kasih nafkah. So that's why dia kena produce receipt whatnot lah. On top of that, dia kena kat sumpah lagi sebab he's denying the allegation. Okay. So that's a general rule. So let's see apa dia punya authority for this. This is belum lagi lah you. So the Quran is Surah An-Nur ayat 24. Surah 24 ayat 4. Okay, for those who accuse honorable women of unchastity but do not produce 4 male witnesses, flog them with 80 lashes and do not admit their testimony forever. They are intrigued transgressors. Bermakna kalau you make an allegation to a chaste woman, you allege that they commit adultery, you have to come up with 4 witnesses. Okay, 4 male witnesses. Bukan witness saja, dia kena male witnesses. Okay, if you do not come up with 4 male witnesses, therefore you have to bear the punishment, which is 80 lashes, and the testimony will not be accepted forever. Ini kalau qazaf lah. So this is a ayat Quran to show that you need evidence, you know, when you want to come to court, when you want to make an allegation, you need evidence to support your case. Okay, next. Okay, we have the hadith. Evidence is, this is al-bayna ala mudai wal yamin ala man ankara. That's the first hadith. Second is your evidence or his oath. Okay, so kita ada legal maxim bahawa al-majalah article 76 sama juga. Dia actually dia ambil hadis tu balik. Al-bayna ala mudai wal yamin ala man ankara. Okay, next. Okay, so apa dia punya legal maxims on the burden of proof? Okay, we have the first legal maxim is that ni kaedah usul fiqh ya. What is apparent is to be the original state and everybody is presumed to be innocent. Lepas tu any claim to the contrary is substantiated with proof. Okay, next. Okay, this is the first maxim. Dekat article 5 of the majalah, the presumption of originality. Al-aslu baqa ma kana ala ma kan. Remaining of a thing in a state in which it was found is the presumption al-asal. So maknanya benda tu as it is. Katalah contoh for example, in terms of nafkah. Hakikatnya the fact is that husband kasih nafkah. Jadi kalau husband tak kasih nafkah, you kena provide kena prove otherwise. So the presumption of law is that the fact remains as it is unless there is proof to the contrary. So the premise is that husband wajib, the father must give nafkah to the anak. Okay. But if the father doesn't give nafkah to the anak, you have to prove against that. Okay. This is the first presumption of originality. Okay, second one. Ni legal maxim yang berkaitan dengan burden of proof. Next. Okay, the second one is Article 8, presumption of innocence. You know, so al-aslu bara'ati zimmah. The original presumption is that a person is free from any liability. Jadi everyone is presumed innocent, okay, until proven guilty. Jadi semua orang tak bersalah. You tak bersalah, I tak bersalah, Fatah Amin tak bersalah. Unless Fazrul prove that betul-betul dia tak kasih nafkah pada anak dia, then dia bersalah. Okay, so that this is the second presumption of innocence. Okay, next. The third one, presumption of non-existent. Okay, al-aslu fi as-safat al-aridah al-adam. So maknanya as to attribute which may exist or not, the presumption is that they do not exist. They basically based on al-aslul adam. Bermakna asalnya benda tu tak ada. The original presumption is that something is that they do not exist. Contoh macam isu kasih nafkah pada anak. Okay. Hakikatnya the father must give nafkah to the anak. So the fact that dia tak kasih nafkah tu tidak wujud unless you prove otherwise. Okay. Next. Okay. Number 10, presumption of continuity of fact. Anything which has been proven at any particular time will continue to exist unless proven otherwise. Alia, are you okay? Alia, dia punya slide hilang, Alia. Kejap ya. Alia. Sekejap, I contact Alia kejap I think dia terkeluar. Is Alia inside the call?
Yes, doctor. It's just I need to admit everyone in first.
You tak boleh, mungkin kena minta orang lain share slide kot. Send you.
Why not Alia share the slide in the group, and then somebody can share the slide, because Alia's in charge of admitting people in.
Okay, let me share the slides in the group. Okay. Okay, so siapa nak share? Okay, dah share dah. Okay. So kalau Alia ni, can anyone share? Siapa nak
I
share?
can do it.
Okay,
Thank
Iman.
you very much.
Iman tolong share kan, Iman?
All right, give me a moment.
Nah. Okay, thank you. Okay, so we'll continue. Bawa lagi? I rasa lagi. Lagi. Some more? Bawa lagi. Okay, number 10. Okay. Number 10. You boleh besarkan lagi tak, Alia? Ni, Iman. Okay. Thank you. So anything which has been proven at any particular time will continue to exist unless proven otherwise. So the fact that same example, Fatah Amin dengan anak dia. So the presumption is that he is giving nafkah. So the fact that selagi anak dia ada, selagi tu dia kasih nafkah. Unless proven otherwise lah. Okay, next. Okay, this is article 76. Is related to the hadith. Al-baina ala mudai wal yamin ala man ankara. Jadi evidence is on the person who claims and oath is on the person who denies. Okay, next. Article 77. Okay. So this maxim says evidence is to prove what is contrary to the apparent fact, and oath is to ensure the continuity of the original state. So this is a continuation. What is the purpose of a proof? To prove what is contrary to the apparent, and an oath to ensure the continuance of the original state. Okay. So now we'll talk about the Federal Territory Act. So you have section 72, 73, 74. Okay, let's look at the sections next. Okay, so section 2 of the Sharia Court Evidence Act, Federal Territory, it embodies the hadith al-bayna ala mudai wal yamin ala man ankara, where the burden to provide evidence in civil cases lies upon the person who alleges or who asserts a fact, which is called the al-mudai, and the person who take oath to deny or dispute the fact is called al-muda'a alayh. So this is called the burden of proof lah. So kalau you nak cerita pasal burden of proof, you must mention section 72. Okay. Jadi dia punya flow tu, the flow, mula-mula you when you tackle the question for burden of proof, you tackle by actually explaining the definition, and then you go into the authority. You have Surah An-Nur verse 4, right? Then you have the hadith. You have two hadiths there. One is al-bayna ala mudai wal yamina ala man akra. Then there's another hadith. And you go straight into the principles, the kaidah usul of fiqh, which is related to burden of proof. You have article berapa tadi? Article 5, is it? I think a few lah kita mention al-aslu adam, everybody is presumed innocent, is innocent till proven guilty, but the fact remains that dekat atas tadi lah. Okay. So now we talk about section 72. So when you go into the act, you talk about section 72, which is sama juga dengan dia punya hadis tu. Okay, next. Then you have section 77. Okay, section 72, dia cross-reference tau. There are some sections where you have to refer to other sections to support this. Okay, so this is cross-reference dengan section 87. of the same act, where it says in 87 subsection 1, in a civil case, evidence shall be given by the plaintiff. Jadi this is sama juga, sama dengan section 72 tadi. Okay? Okay, next. Okay, 73. Okay, why I'm emphasizing the section, because it's important when you answer the question, when you do your assignment, your presentation, you must mention the section. Pasal we are studying law, therefore we need to know how to read the act. Okay, section 73 says that whoever desires any court to give judgment as to any legal right or liability, which is dependent on the existence of facts, which he asserts, must prove that those facts exist. So kalau you make an assertion, you make a claim, you have to prove that particular claim exists. If you claim that your husband can pay you muta'ah 100 million, prove it that he can afford it. So you have to prove to court that he can afford to pay that much. Okay, subsection 2. When a person is bound to prove the existence of a fact, it is said that the burden of proof lies upon that person. Faham? So if you are asserting that you are claiming nafkah, if you're claiming mut'ah for 100 million, macam dekat case Shahnas punya case, she got married to, I think, one of the richest men in Sarawak. So they divorced after, I think, marrying for like 16 years or 20 years. They got a divorce. So because he's a billionaire, so she claimed from him 100 million. So here, based on section 73, she alleges that he has billions of property overseas. Therefore, he can afford to give her muta'ah for 100 million. Okay. So here, she has to prove to court that he indeed has billions of, dollars, that he can actually pay her muta'ah 100 million. Faham? So it's upon her. So the burden of proof is upon Shahnas to prove. Boleh? Okay, we look at the illustration. A desires a court to give judgment that B shall be punished for a crime which A says B has committed. Jadi A must prove that B actually committed the crime. Boleh? Okay, next section. Section 74. On whom the burden of proof lies. Okay. Section 74 talks about the burden of proof in a suit or proceeding lies on the person who would fail if no evidence at all were given on either side. Okay, faham eh? Okay, let's recap. Section 72 talks about what? Anyone? You have the notes. Anyone? Come on. Section 2 cakap pasal apa?
Burden to produce evidence in a civil case lah.
To be more clear, Section 72 talks about the hadith actually lah, where the burden of proof is on the claimant, and the person who denies must come up with an oath. Okay. Section 73 cakap apa? Come on, Section 73 cakap apa? Anyone? Nurin? Section 73 cakap apa?
It said on the facts come out from the claimant, and the claimant must prove that facts is true.
Okay. So it's actually an extension of Section 72, whereby if you assert a particular fact, you must prove that particular fact. Okay. So Section 74 talks about if you do not produce the evidence, therefore, dia macam ni tau, burden of proof is on the person who alleges tapi dia tak kukuhkan evidence. Therefore, tak boleh. I put it differently. Burden of proof in a suit lies on the person who, if dia tak produce evidence, therefore dia punya case akan fail. Sama juga maksud dia. Tapi in a different way lah. Yeah? Boleh? So this is burden of proof as to a particular fact. So yang involve section 72, 73 dan 74. Okay. So next. So we'll talk about the cases. So basically, to prove this, we have 3 cases. Case Rajamah binti Muhammad against Abdul Wahab Long, Aisyah binti Abdul Rauf, and Wan Muhammad Yusof. Pendakwa Syariah Kelantan against Wan Rahim bin Nick and Nick Azimah. Okay, so we'll talk about the first case. Okay, Rajmah binti Muhammad against Abdul Wahab Long. Okay, so this is an example where the Syariah court, ni case polygamy tau. This is a polygamy case. So during the trial court, the judge ruled in favor of the respondent. Okay. Why? Okay. Kenapa? Sebab the respondent tu the dekat mahkamah rendah, okay, the court allowed the polygamy in favor of the respondent. Why? Pasal after considering the polygamy did take place. Tapi bila dia pergi appeal, mahkamah rayuan said that he couldn't prove that he actually, in terms of income, in terms of finance, he couldn't actually mampu. Dia tak layak untuk berpoligami. Okay. So because of that, the court overturned the decision. Okay, this is case polygamy, whereby he failed to prove to the court that actually I ni mampu nak polygamy. Because there are many reasons, for you to enter into a polygamous marriage. One of the reasons is that you must actually show that perkahwinan tu patut, perlu, dan you mampu, kemampuan tu penting. So in this instance, the lower court failed to consider that dia ni tak mampu. So bila pergi ke mahkamah rayuan kata, yes, dia ni memang tak mampu. Dia tak buktikan kemampuan dia untuk berpoligami. Therefore, his application for polygamy was rejected. Okay, the decision was overturned. Okay, let's go to the next case. Okay, Aisyah against Abdul Rauf binti Abdul Rauf versus Wan Muhammad Yusof. Sama juga, case polygamy juga. So in this case, the husband failed to prove that dia ni mampu. Okay, kalau dia punya requirement tu dekat situ, the court must be satisfied that the proposed marriage is just unnecessary, that the application means to support the both wives lah. So in this case, he failed to prove to the court that he could actually exercise polygamy because dia tak dapat buktikan kemampuan dia nak tanggung dia punya wife lah in terms of finance. Okay, so Rajma Aisyah polygamy punya case. Third, okay, this is case pendakwa Syariah Kelantan melawat Muhammad Rahim. So dekat sini there was documentary evidence, which was being certified. Tapi dia punya pendakwa itu was not happy, so the burden of proof was on him to prove that the document was not true, was a false document. Okay, next. Okay, so we have other cases. We have the case of dalam perkara permohonan poligami Ruzaini, Risalih binti Swati, Nur Azian binti Muhammad Yusof versus Khairul Azmi, Nur Wasitah binti Haji Panut versus Muhammad Azri, Wan Shiram Syabani bin Wan Ramli versus Ni Adura Hazlin, JA versus NY. Okay, so we'll cover a few cases. So let's look at the first case. Okay, dalam perkara permohonan poligami Ruzaini binti Hasan, sama juga, isu income, dia tak mampu. In polygamy cases, it's very important in order for you to be able to get the decision for polygamy, the approval to enter into a polygamous marriage, you must first prove to the court that you actually can afford to get married, afford in terms of finance. So in this case, similarly, he could not prove to the court that he actually had extra income to take up a second wife. Okay, next. So we have the case of Wan Shiram Syabani bin Wan Ramli versus Nik Adura Hazlin. Okay, ni case taklid. So the plaintiff, the respondent claim for taklid but was not able to prove, although that she had 2 witnesses being tendered into court. So the witness was not able to actually explain. Kalau taklid ni maksudnya macam ni, tahu apa ni cara taklid tu macam mana? Cerai cara taklik tu ada dua tau. Sama ada satu you ada langgar taklik. Husband you kata jangan keluar rumah tapi you keluar rumah. Itu dah langgar taklik. Ataupun taklik belakang surat nikah tu lah. Tapi I think in this instance it's more of cerai. Husband letak condition, you langgar the condition. So you telah langgar taklik husband you lah. Macam tu. So here she brought forth two witnesses. But the witnesses could not explain what actually happened. How pelanggaran taklik tu berlaku. Okay. So therefore, so burden of proof was still upon the plaintiff pasal dia tak discharge lagi dia punya burden of proof. Jadi the decision for the court to confirm the taklik was set aside because she could not prove that the pelanggaran taklik tu actually happened, so she failed her case. Okay, next. So I sentuh cuma 2 cases saja, the rest you kena baca sendiri. Okay, so now the general rule is that the burden of proof is upon the claimant who alleges, who makes the tuntutan. Okay, tapi ni kita panggil ni shifting of the burden of proof. In what circumstances will the burden of proof shift from the plaintiff to the defendant? Instead of you alleging, pihak defendant pula kena buktikan case, bukan you. Okay. Jadi first kita di section 75. Burden of proof as to a particular fact. So for this one kita ada surah Al-Namlu ayat 20 hingga 27. We have one case for this, Muhammad bin Haji Muhammadiyah versus Pendahulu Syariah Kelantan. And then we have section 77 which talks about burden of proof of cases where the accused comes within exception. So we have one case, Muhammad Azam Sharif versus Sheikh Nurina Long. So let's look at the first section. Berapa lagi? Okay. So section 75 ni kita panggil ni defense of alibi. Alibi ni maksudnya apa? Alibi ni you ada somebody to prove that you were there. Contoh, there was a murder, okay? And people suspect that you actually, kata dah Ali dengan Abu was killed. So Ali happened to, and then somehow or other Ali was accused of killing Abu. Okay, but then Ali said, I wasn't there at that point of time. During that time, I was actually at my mother's place, which was like 20 kilometers away. How is it possible that I'm there when I'm somewhere else? So this is what you call defense of alibi. Okay, so kalau defense of alibi, the burden of proof to any particular fact lies on the person who wishes the court to believe in existence. Contoh, A wishes the court to believe that at that time in question he was elsewhere. So he must prove to the court that he was not there, but he was somewhere else. So you call this defense of alibi. Okay, next. Dia cross-reference tau. Sorry, atas tadi. Okay, bawah. So dia cross-reference dengan section 187 of the Shariah Criminal Procedure Act. So dekat sini, dia cerita pasal defense of alibi. Yang ni cerita dia punya procedure, how do you nak proceed pasal defense of alibi. So nanti you can just read that. This I just nak bagi tahu that's a cross-reference section yang related to that. Next. Okay, so we'll look at this case. Case of pendakwa Muhammad bin Haji Muhammadiyah versus pendakwa Syariah Kelantan. Okay, this is the case of he was committed for an act of solemnizing the marriage of several couples without legal authority from the religious authority. Okay. Bila you nak nikah, you kena ada juru nikah tau. So in this case, juru nikah tu tak bertauliah. He didn't have the legal authority to actually perform the solemnization ceremony. Okay. So when you have a juru nikah who doesn't have authority, what happens to your nikah? It's not valid. Okay. So this was the issue here. So here he was accused of solemnizing the marriage of several couples, not one, but many couples, without having the legal authority from the religious authority. So here he raised the issue of alibi. Dia kata that he was in Thailand on that, it was argued in the appeal that he was in Thailand on that particular day. Therefore, the conviction being made by the trial court was void. So in appeal, the appeal was rejected as the defense failed to prove that he was in the whole day in Thailand. Okay. So dia claim dia tak dekat situ, dia dekat Thailand. Okay, tapi the appeal was rejected sebab apa defense tu couldn't, there is the defense of alibi, but they couldn't prove that he was in Thailand. Okay, next. Okay. So we'll talk about section 77. Section 77 tu adalah when a person is accused of any offence, the burden of proof of the existence of circumstances bringing the case within any of the general exceptions provided in the Shariah criminal offences is upon him, and the court shall presume the absence of those circumstances. Okay, contoh A is accused of unlawful cohabitation with B, persetubuhan haram. The prosecution produces evidence to show that A had divorced his wife B. A claims that he was forced to divorce his wife. So the burden of proof lies upon A. Okay. Faham tak maksud dia? Okay.
Kurang faham medium.
Okay. A ni ditubuh persetubuhan haram tau dengan dia punya wife. Okay. Kalau you dah bercerai dengan your wife, okay, she is no longer your wife. So kalau you have sex with your wife, you know, without actually uttering rujuk, that is already considered zina tau. Okay. So in this case, dia dituduh persetubuhan haram dengan B, which was actually dia punya ex-wife. So the prosecution produced evidence to show that A ni dah ceraikan dia punya wife ni. Tapi kata, sebenarnya I bukan saja-saja cerai I punya wife ni, I dipaksa cerai I punya wife. I was forced. Jadi kalau you tengok one of the defense of criminal, kalau force tu kan coerce kan, coerce tu termasuk bahawa paksaan kan. So dia kena buktikan lah dekat mahkamah bahawa sebenarnya dia memang ada unsur-unsur paksaan dia menceraikan dia punya wife. Contohlah macam ada orang letak pisau kat leher dia, kalau nak tembak dia, you know, kalau dia tak ceraikan dia punya wife lah. So in those circumstances he has to prove lah. If let's say dia berjaya tunjukkan there was element of memang dia kena paksa, therefore kan, therefore it is said the burden of proof is upon him. He has to prove to court. Faham tak? You nampak tak dekat mana dia punya burden of proof berpindah? Okay, kalau dalam ni case criminal tau. Dalam case in this kind of cases, biasanya the prosecution yang kena prove kan. Tapi the prosecution tu dah tunjuk evidence. Dah kata, okay memang sekarang ni ada bukti yang you dah ceraikan you punya wife. Jadi apa bukti yang you kata you tak ceraikan you punya wife? So dia kena come up dengan bukti lah. So he has to prove the case, which actually the reason comes within exceptional, general exceptions provided by the Shariah criminal offences. The defense lah. Yeah? Boleh? Okay, kita tengok illustration B pula. C is accused of committing unlawful sexual intercourse. Sama juga persetubuhan haram with D. C claims that he had already married D in a foreign country. So the burden of proving that such marriage took place lies on C. Burden of proving especially within the knowledge. Jadi dia kena prove that memang ada surat nikah, dia kena produce surat nikah dekat overseas yang dia dah kahwin sebenarnya. So the burden of proof is shifted upon him. Nampak? Okay, jom tengok contoh dia. Okay. Tu contoh dia. Nanti cari kita punya case. Okay, section 78 burden of proof of proving fact especially within knowledge. Okay. So section 78 ni bermakna you kena ada particular knowledge. So let's look at the section. Okay. Section 78 ni you kena ada special knowledge. When any fact is especially within the knowledge of any person, the burden of proof is upon that particular person. Kalau ada any special knowledge, is upon you to prove to court that it actually exists. Contoh, when a person does an act with some intention other than that which the character and circumstances of the act suggest, the burden of proof of that intention is upon him. Okay, kita tengok example. Tengok the next case. Okay, so let's look at this case. This is what happened in this case. Abdul Rahman Saleh versus and satu lagi versus pendakwa hal ehwal agama Islam Terengganu. Okay, Abdul Rahman Saleh was charged for performing solat Jumaat in a surau, Pakda Malik, okay, which was not gazetted. Okay, in order to perform solat Jumaat, it must be performed at a place ke a surau ke a masjid yang gazetted that you can perform solat Jumaat. So if you perform dekat surau yang tak gazetted, it's considered an offence. Okay. Tapi dekat sini kena bear in mind juga lah the fact that ada judicial notice under section 105 dengan 106 of the Act that the burden lays upon the appellant to prove that Friday prayers could not be held at the surau. Okay, so in this case, the appellant failed to do so. So bermakna that appellant ni, which is Abdul Rahman tu, kena buktikan dekat mahkamah bahawa sebenarnya tempat tu memang dia dah dapat dah. It is being gazetted for him to do Friday prayers lah. Okay, so kalau you tengok bawah lagi boleh, wording in the text. Section 107 memperuntukkan bahawa apabila suatu fakta yang adalah khasnya diketahui oleh seseorang, maka beban bagi membuktikan fakta itu terletak atasnya. Okay. So here, if he has the knowledge, of a particular fact, contoh macam he has the knowledge that the surau has been gazetted to do Friday prayers. So it is upon him to prove the fact. Okay. Dalam kes ini boleh dikatakan bahawa beban membuktikan bahawa solat Jumaat boleh diadakan di surau yang berkenaan itu adalah dipikul oleh orang yang dituduh itu. Yang dituduh itu sebetulnya tidak membuktikan bahawa surau itu telah diluluskan sebagai tempat di mana boleh diadakan sembahyang Jumaat. Faham tak kes ni? So dia dituduh perform solat Jumaat, jadi imam lah dekat surau tu yang tidak digazetkan. So is upon him. So he said he has a knowledge, dah dapat kelulusan, dah digazetkan untuk buat solat Jumaat. Tapi dia tak buktikan. Because under section 106, he has to prove. The burden is upon him to prove that surau tu memang digazetkan untuk solat Jumaat. Faham? Boleh? Okay, thank you Iman. Okay, thank you Amelia. Dia pun faham. Okay, next. Okay. So we look into Pakistan pula. Pakistan ada part 3, chapter 4, which talks about burden of proof. Jadi you ada article 117, talks about burden of proof, 118, on whom the burden of proof lies, 119, burden of proof as to a particular fact, 121, burden of proof of the case of the accused that comes with an exception, 122, burden of proof especially with the knowledge. 122 ni section 78 tadi, within exception tu adalah section 70 apa tadi? 6 is it? Cuba ni atas balik ni tadi. Iman, atas lagi. Okay, special knowledge section 78, atas lagi. General 77 kan? Yeah, general provisions, general exception 77, 75 is defense of alibi. So you kena ingat tau, only in these 3 circumstances, the burden of proof shifts to the other party. Okay, 75, defense of alibi, 77, general exceptions. Okay, 78, special knowledge. Okay, cases you kena ingat tadi, cases apa Muhammadiyah tu for 75, 77 you kena cari dia punya case, 78 tadi apa? Buka bawah tadi. Abdul Rahman Saleh, kes pasal masjid solat Jumaat. Okay, bawah lagi. Lagi bawah. Okay, so now kita talk about Brunei pula. Okay, dekat Brunei, production of evidence, part 3, section 90, burden of proof, section 91, on whom the burden of proof lies. Kalau you nampak dia sama tau, macam tadi kita cerita pasal section 72 kan, 72 sama dengan burden of proof, 73 sama dengan on whom the burden of proof lies, 74, 72, okay, adalah burden of proof as to a particular fact, 94 and 95. Okay, next.
Dah habis.
Wow, cepat eh. Faham tak so far? This is important eh. This is very important. So let's look at your tutorial questions. Okay, ada a few queries. Okay, how nak present eh. So let's look at your tutorial questions. Okay, so what you need to do. Okay, pertama sekali you kena identify the issue. Okay, let's look at an example lah. Kita ambil contoh question number 1 kan. Discuss the development of Islamic law of evidence in Malaysia starting from 1952 and its codification. Similarities and differences until nowadays. Okay, so this is a very straightforward question lah. dia punya isu tu pasal discuss the development. Jadi you kena discuss lah dia punya background macam mana, sejarah dia, and then go to phase 1, phase 2. Okay, buka balik yang tu, yang atas tu the description. Phase 1, phase 2, phase 3. Lepas tu compare similarities and what not. So I rasa in terms of the first question tu mungkin tak ada ayat Quran kan? Ada tak? Macam tak ada je kan? Tapi I think there's a case law for that. So you can use the case law. Okay. So untuk approach problem question, let's look at the problem question. Okay, question number 6. Yeah. Mak Jomo informed his friends Mamat and Mahmud that he had divorced his wife, Hawa, with triple talaq. Okay. He sought their opinion on how he might reconcile with her. Okay. But their response was unfortunately unsatisfactory to him. Meanwhile, Hawa had initiated proceedings in the Shariah court to officially register the divorce. When Mak Jamur was summoned to confirm the divorce, he refuted the claim, asserting to the court that he had only pronounced one talaq. Consequently, the Shariah judge adjourned the case and instructed Hawa to produce 2 witnesses to corroborate her assertion that Mak Jamur has pronounced a triple talaq. Otherwise, the court will only grant one talaq. So Hawa came to your advice. Based on the authority in Islamic law of evidence and the current legal practices, please advise her as to the burden of proof. Okay, ni kita baru belajar burden of proof tau. Jadi what you need to do is you have to dissect this question, identify who are the parties involved. Mak Jomo, kawan-kawan dia siapa? Identify who are the parties. Okay, so apa isunya sekarang ni? Isunya pasal triple talaq. Mak Jomo pronounced triple, Hawa claim that Mak Jomo pronounced triple talaq. Okay, but Mak Jomo kata no, is only one talaq. Okay, so right now, on who the burden of proof lies? On whom? On whom? Siapa kena buktikan? Siapa kena buktikan?
Mak Jomo.
Mak Jomo, siapa kena buktikan dekat sini?
Maybe the wife, Hawa.
Yeah, the burden of proof is on the wife lah. So right now you kena, sebab kalau you tengok dia punya soalan tu dah very specific lah. Hawa came to your advice based on the authority in Islamic law of evidence and the current legal practice, advise her as to burden of proof. Jadi kita discuss lah what is burden of proof. Okay, definition, kenapa benda tu penting. Penting tak penting sangat lah. Okay, and then you go to the authority. Apa authority for burden of proof? You can quote surah An-Nisa ayat 4. The hadith, the 2 hadith, So you can also quote, kalau in terms of macam ni, kita boleh refer to legal maxim apa dia. And then you go directly kepada on who lies the burden of proof. Quote section 72, 73, 74. Macam tu. Okay. So dekat sini discuss the position of Mamat and Mahmud who refuse to be involved in family affairs of Mak Jomo. This goes to the responsibility of actually coming forth to give evidence. Ni kita dah cover kan dekat topik last week kan. So it's a mixture of both. So when you approach the question, you need to in terms of satu, this is how I prefer you to answer now. Satu, in terms of defining what is the definition of burden of proof. Second, you quote your authority, Quran, Sunnah, practices of the Sahabat, if any, opinions of the jurists, provisions in the majalah ke legal maxim dalam usul fiqh kan. And then you relate the issue, apa dia punya law. So bila kita cerita pasal law, therefore kita cerita pasal dia punya section lah. So when you quote a particular section, you relate back to the case. Okay. You quote a section, contoh macam just now kan, section 75. Katalah it comes within section 75, falls under the exception of section 75. Okay, then you quote a case. And then you relate balik. So let's say like you nak cerita totally pasal burden of proof kan, kita boleh guna case apa tadi? Burden of proof punya case just now. Yang banyak case poligami tu kan, case Aisyah ke, you can use that case to show that in this case his application untuk polygamy was rejected pasal he didn't show proof to court, because the burden of proof is upon him to show this to the court. So dekat sini kalau dia nak kata, because right now kalau dekat mahkamah mana-mana, hakim akan sabitkan talak 1. So kalau you tak puas hati katanya talak 3, you kena proof to court. So cara dia nak proof dekat court, dia kena kemukakan evidence lah by way of 2 saksi bebas lah. Faham So you have to dissect satu persatu. Okay. And then kalau ikut sini, yang kita nak ni cases, decided cases. And then if you can find a statement from the judge, an obiter dicta daripada penghakiman tu kan, a sentence di mana hakim kata macam gini, you can quote that. And then you apply balik dekat your case. Based on this particular case, apply the law to the present case. In this case, apa Umi Hama boleh buat. Sama juga macam position Mamat dengan Mahmud tu, ini isu giving, on whose responsibility is it to give testimony. Adakah ini kes jenayah ataupun kes mal? Kalau kes jenayah, position dia macam mana? Is it a hudud case? Kalau hudud case, you kena sorok kan? Tapi kalau sekiranya kes ni kes mal, macam mana kedudukan dia? Do you have to actually give the testimony? Or do you have, let's say, what happens if you had knowledge but you refuse to? Hukumnya macam mana? Discuss about that. Boleh? Any questions so far? Thank you, Edina. So kalau you tengok dia punya soalan tu, dia vary tau. I think we have like 70 questions. So how many are we in this section? Ada berapa orang? Cukup ke Alia semua soalan dah, are there takers for all the questions?
So far, not all.
Not all. Tapi dah semua orang dah letak soalan ke? Dah letak the preference of question ke? Belum
Yes,
lagi?
madam.
Dah letak dah, okay. So,
Doctor, I
Yeah.
want to ask, the written submission 1 week after the presentation?
okay, you present first, I will comment, okay? So, bila you present, you kena print out your presentation so I can refer to your presentation, you know. There will be marks on your presentation on that day. Tapi nanti written submission tu you boleh perbetulkan sikit on my comment, okay? So,
Alright, Doctor.
yeah, I will give it a week after you dah present, you boleh submit your written submission. To be fair to everyone. So kita go by sequence lah, maknanya let's say kita akan start dengan nombor 1, 2, 3. Sekiranya nombor 1 ada tapi nombor 2 tak ada orang. Yang ada nombor 10. Okay, so nombor 1, nombor 10. Faham ni? Dikut ni lah. Sebab kita baru belajar pun takut burden of proof kan? Betul dengan shifting of burden of proof, yang lain tu belum belajar lagi. So yang first come first serve, maknanya by 28 kita dah cover lah. Mungkin by next week kita dah masuk ikrar lah, dan banyak sikit that you boleh tulis lah. So for next week kita akan start this time ni. InsyaAllah next week tangan I dah okay sikit kot. I dah boleh drive kan insyaAllah next week. So Monday kita akan jumpa dekat kita punya physical, because for presentation I prefer to be physical. Yeah. So all of you are supposed to, I mean, if you belong to that particular tutorial section, datang, so you can give support to your friend and you can also learn as well. So the allocation of time, each person is allotted 15 minutes. You have 2 minutes to set up, because I understand sometimes it's difficult, you know, sometimes you don't have the internet connection, you know, your slide doesn't come out, so that will take a few minutes, you know. Your actual presentation is 10 minutes. And then after that, I allocate about 3 minutes to ask questions. I ask questions, you answer. So you are going to be judged 10%, 10 marks on how your oral presentation, overall how you present, you know, how you tackle the question that I asked, whether you understand or not what you're actually presenting. And then the remaining 10 marks will be based on your written submission, as well as your presentation, the slides as well. Okay? Any other questions?
The doctor,
Yeah.
ada last question. Yang review 3 decided cases tu, not more than 6 pages. Is it overall the 3 decided cases? Yang 6 pages?
Yeah, yang this is for you're asking pasal group assignment, right?
Yes.
Okay. Yes, group assignment pasal I tak nak baca banyak sangat. So let's say kita will review 3 decided cases within 6 pages kan maknanya? Mungkin 2.
Maksudnya macam 6 pages overall 3 decided cases tu ke madam maksudnya?
Yes.
Okay.
Bukan
Thank you.
6 pages ya. How many pages would that be? A lot of pages. So I would expect you to write within probably 15 to 16 pages. Okay. So that's it lah. Dia punya group assignment deadline dia 31 Disember this year. You have ample time. Okay. I think I give the instruction dalam dia punya group assignment kan. So while you're working on your presentation, you can start finding materials for the group assignment as well. Okay. Boleh? Any more questions?
Madam, tanya yang
Yeah.
3 decided cases tu kena relate dengan topik written, group written tu ke? Ataupun any area?
3 decided cases, kita tanya pasal group assignment, right?
Yes.
Sebab
Sebab
kalau let's say topik you pasal ikrar, you kena cerita pasal ikrar lah, ikrar in civil cases. You have to talk pasal ikrar dengan civil cases lah. Takkan nak cerita pasal tiba-tiba ikrar pasal kes jenayah pula. You know, that will be out of the, if you do actually letak satu case, tapi you punya issue, you punya question tu is on civil cases, ikrar in civil cases. Tapi you ambil contoh case kan, ikrar dekat kes jenayah, kes persuahan haram. You are not answering the questions, therefore you'll not get marks walaupun kes tu betul. Faham tak?
Faham. Thank you, madam.
Any other questions?
I actually have a question, but it's regarding the lesson today.
Yeah.
So for the what do you call say kan kita say the polygamy case, the court said made the decision that the man does not have the capacity to take up another wife, tapi dibuat juga by going to like Thailand, let's say. Does that mean dia is contempt of court ke macam mana?
Okay, ini banyak berlaku tau dekat mahkamah, because dekat mahkamah to get approval for polygamy is very difficult because there's so many things that you have to actually show to the court that you betul-betul mampu. Contoh kalau gaji you 2,000, you bawa lori gaji you 2,000, anak 8, you nak kahwin 2. Memang tak mampu lah obviously kan. So nak juga kahwin 2, so diorang lari pergi sepadan kahwin kat Siam. So when that happens, okay, court dah keluarkan arahan you tak boleh kahwin. Kan, there's a court order that polygamy tidak dibenarkan. So diorang pergi lari kat Siam, kahwin juga dekat Siam. Satu, there's a violation of the court order. Keduanya, you dah kahwin, violation of the court order, you dah nikah tanpa kebenaran polygamy, you nikah dekat dua negara sama. So penalty tu banyak dah yang you kena tu. 3 lah kesalahan you.
But the marriage is valid lah.
The marriage is valid sekiranya dinikahkan mengikut undang-undang syariah di sana. Tapi kita kena make sure, lepas tu bila nak daftarkan balik kat Malaysia, kita kena make sure that imam yang menikahkan tu imam yang bertauliah, yang kita recognize. Because you may nikah, you sometimes you have nikah syndicate, you know. You just nikah tapi tah imam tu memang tak ada tauliah. I pernah kenalikan this one case, my friend now, she got married. So what happened was that bila anak dia lahir, dia nak buat surat kelahiran anak dan sijil lahir anak dia. Tapi bila pergi kat JPN kata your surat nikah ni tak valid. Dia pun terkejut. So she contacted me. So I pun buatlah search dekat Majlis Agama Islam kan. So bila kita check, kita kasihlah fotokopi surat nikah tu. So they check inside the system, memang surat nikah tu tak wujud dia punya nombor pendaftaran dia, nombor siri dia. So I tanya kat dia, macam mana you nikah? So dia kata, kita nikah, my husband bawa I, we were brought to one place, we were like dibungkus, masuk dekat hotel tak mana-mana, don't know where, lepas tu tahu-tahu dah ada orang untuk nikahkan kita, lepas tu kita nikah, lepas tu bila kita nak keluar, kita diserubung balik, lepas tu kita bawa keluar macam tu. So I kata kat dia, ni mungkin nikah sindiket lah, so jadi I advise better you nikah semula. Pasal nikah tu memang tak sah, surat nikah you tak wujud. So that's the reason why bila you daftar kat luar negara, you balik Malaysia, you kena daftarkan perkahwinan you. Because not necessarily you nikah kat luar negara, benda tu sah kat Malaysia. If let's say imam tu tak ada tauliah daripada kita punya Jabatan Agama Islam, we do not recognize imam tu. Therefore pernikahan tidak sah. Simple as that. Did I answer your question, Iman?
Yes, you did. Thank you.
Any more questions? Tak ada. Okay, so I'll see you on Thursday. Nanti Alia buat link ya. Thursday.
Okay.
Berapa? Pukul 4.5 Thursday? 4.5 right?
Yep, betul.
So I'll see you on next Thursday, kita sambung lagi pasal burden of proof lagi. Sikit lagi. Dan kita masuk ikrar kelas 4 lah. Kalau tidak, the next week masuk ikrar. Okay? So apa ni, Alia, you check attendance, Alia, you ambil screenshot.
Dah made them.
Dah, thank you.
Alright.
Okay, see you on Thursday. Bye bye.
Bye bye. Thank you, Dora.
Thank you, madam.